Welcome friends to a new session on Informatics and Introduction to Bioinformatics. Basic Concepts of IPR, Copyrights and Patents, Part 1. Intellectual property rights have become important in the face of changing trade environment, which is characterized by the following features, namely global competition, high innovation risks, short product cycle, need for rapid changes in technology, high investments in research and development, production and marketing, and need for highly skilled human resources. The creator or producer of the information is the real owner of the information. It protects the rights of individuals and businesses who have transformed their ideas into property by granting rights into the owners of those properties. The intangible property created by individual or corporation, which is protected under trademarks, patent and copyright laws, is called intellectual property and intellectual property right. IPR is a collective term which includes all these laws. The concept of intellectual property will be understood better if we understand what is meant by the term property. To a layman, property means some material object belonging to a particular person. The concept of ownership is critical to the concept of property. Ownership means the right to possess, use and dispose of the property and at the desire of the owner to exclude the others. If a society does not recognize ownership, it will not have a concept of property. In the legal sense, property refers to the bundle of rights that the law confers on a person by virtue of the ownership and possession of an object. The first intellectual property law was passed in Venice in the year 1474. The IPR universalized with the birth of the Paris Convention of Industrial Property in 1883. The Berne Convention for the Protection of Literary and Artistic Works followed this convention. Types of IPR. IP has been generally divided into two main categories, namely industrial property, copyright. Industrial property consists of rights relating to inventions, trademarks, industrial designs and appellation of origin. Copyright protects rights related to creation of human mind in the fields of literature, music, art and audiovisual works. The TRIPS agreement of the WTO recognizes 7 types of intellectual property rights: copyright and related rights for literary works, trademarks, trade secrets, trade names and service marks, geographical indications, industrial designs, patents for invention, layout designs of integrated circuits, undisclosed information. Copyright. Copyrights are the exclusive right granted by statute to the author of the works to reproduce dramatic, artistic, literary or musical work or to authorize its reproduction by others. The copyright persists for a finite period after the author's death, after which it can be sold or inherited. As such, it protects the expression of the idea rather than the idea itself. It also extends to film or television. Copyrights which comply with international norms like Berne Convention, trade related aspects of international property rights or TRIPS, Agreement and World Intellectual Property Organization WIPO, Copyright Treaty WCT. Normally, the sign is used in printed works to indicate that they are copyrighted. One copy of the work may be filed in Copyright Office as evidence to establish rights of the author. The moment an author writes something original, he or she automatically gets copyright. The copyright provides the following rights to the author: to prepare a derivative work based on the original work, give a performance based on the work if it is a drama, exhibit the work if it is a work of art, translate the work to any language, to make a movie based on the work. No one can violate any of these above rights of the copyright holder without written permission given by him or her. Willful violation of copyright is a criminal offence and can lead the offender to a jail in terms. Exceptions are given in terms of fair use of the copyrighted material. These provisions is meant for educational purpose, which include reviewing a work by quoting portions, distributing portions of the work in class to teach students, doing research using it for public good by non-profit making organizations. The activities which are considered violation of law under book privacy or audio privacy include copyrighting parts of several web pages, cut and paste and give it as your own article, copying verbatim substantial portion of a book in own name excluding few pages, that is plagiarism, making Xerox copies and selling them, Xeroxing the entire book for personal use, borrowing CD and copying the content, etc. Software copyright. Software such as MS Windows, MS Office has a licensing policy which restricts use on one computer only. If there are several computers in the department, each one must have a legal copy. The cost will be high, so the vendors use site license for organizations. Therefore, any information which is transmitted on internet is a subject matter of copyrights. In addition, many pieces of information transferred and transmitted on internet may already be copyrighted. Trademarks. Trademark means any symbol, logo or name used to enable the public to identify the supplier of goods. Trademarks can be registered, which gives the holder the exclusive right to use them. Manufacturers or importers may register them. Trademarks and service marks are distinctive symbols that help the consumer to distinguish between competing goods or services and are a major part of the goodwill a company enjoys in the trade. A trade name is the name of an enterprise which also individualizes the enterprise in the minds of the customers. They are therefore protected as IP. Thus, a trademark is a sign that individualizes the goods of a given enterprise and distinguishes them from the goods of its competitors. You may be quite familiar with the distinctive marks of Pepsi-Cola and Coca-Cola companies. Similarly, in passenger cars, a characteristic star enclosed in a circle or a characteristic tree-like T enclosed in an ellipse displayed in the front and the rear of a vehicle immediately proclaims that the first vehicle is from the Mercedes and the second one is from the Tata's stable. Trademarks invariably come to symbolize quality of goods or services in the customer's mind. However, there is no requirement in law that a trademark has to meet any quality standards. If quality is not maintained, customers will shift to another brand. A trademark is required to be distinctive and not deceptive. If you market goods of fake leather under the trademark real leather, you will be taken in by a deceptive trademark. Trade secrets. Trade secrets are also like patents, but they rely on private measures rather than state action to maintain exclusivity. Recognizing the commercial value of trade secrets and non-patentable know-hows, TRIPS requires members to develop national legislation to protect such information from being disclosed to, acquired by or used by persons without the consent of the person who is lawfully in control of it in a manner contrary to honest commercial practices. Geographical indications. GI. GI is a sign used on goods that have a specific geographical origin and possess qualities or a reputation that is solely due to the place of origin. A GI is different from a trademark. A GI merely tells that a product is produced in a certain place and has certain characteristics which are due to the place of production. All producers who make their products in a place designated by the GI and share the same qualities can use it. The Paris Convention uses two terms in the context of geographical indication: appellation of origin and indication of source. Indication of source on a product merely indicates that the product originates in the place indicated. Appellation of origin indicates not only the place of origin but also the essential quality link between the product and the area of its origin. Example: Kolhapuri chappals from Kolhapur, India. Geographical indications have the potential to improve the welfare of rural communities. Industrial design. An industrial design is the ornamental or aesthetic aspect of an article. It may consist of three-dimensional features such as shape or surface, or of two-dimensional features such as patterns, lines or color. The design serves as a tool for product differentiation and lures customers by enhanced visual appeal. Industrial designs are applied to a wide variety of products of industry or handicraft, such as watches, jewelry, fashion and other luxury items, industrial and medical implements, houseware, furniture, electrical appliances, vehicles and architectural structures, textile designs, toys, etc. An industrial design is distinguished from trademark primarily because it is constituted by the appearance of a product, which is not necessarily distinctive. Design enhances the visual appeal and adds to the commercial value of the product. It also facilitates the marketing and commercialization of the product. For registration, a design needs to be new and original, though the notion of these qualities may vary from country to country. In certain conditions, an industrial design can be protected under copyright law or the law against unfair competition. Patents. A patent is a logically monopoly granted for a limited time to the owner of an invention granted by law. In many countries, an inventor of a new product or process can apply for a patent, giving the holder the exclusive right for a number of years to produce the good or use the process. This right can be used either through their own business or by changing a license fee. Without obtaining a license from the patent holder, the work cannot be used or reproduced. It is property right for an inventor granted by a government to the inventor. Utility patents protect inventions that are novel, non-obvious and useful. Under the TRIPS agreement of the WTO, inventions in all fields of technology, whether products or processes, are patentable if they meet the criteria of novelty, involve an inventive step and are capable of industrial application. Patents are one of the oldest forms of IP protection. The patent system started in the 1700s. The aim of the patent system is to encourage economic and technological development by rewarding intellectual creativity. There are three main types of patents. Utility patents. This is the patent of invention and is used for an invention of a new useful process, machine, manufacture or composition of matter. The duration of the utility patent is 20 years from the date of patent application and is subject to payment of maintenance fee. Design patent. It is issued for a new, original and ornamental design of an article. The duration of such type of patent is 14 years from the date of patent grant. Developments in science now permit the definition of specific genes and open the door to intellectual property rights related to living matter, giving rise to concerns about the exploitation of plant genetic resources. Plant patent. This type of patent applies to characteristic of a new plant that has been asexually produced. The duration of the planned patent is 20 years from the date of filing application of patent. Procedures for patent filing. An inventor must register his invention in each country where he wants the product to be protected. Depending on the IPR protection laws of that country, the inventor is denied or granted total or partial protection of his product or process for a number of years, after which the invention moves into the public domain and can be used by anyone. In patenting, the person who brings the original patentable item is called inventor. The person or entity who is filling the application is called applicant, and the legal representative who is filling patent on behalf of others and providing service to them is called the patent attorney or agent. Steps involved in patent filing are: conceptualization of idea. It includes inventing or contriving an idea or explanation and formulating it mentally. Documenting the invention. Prior art search. During this stage, the invention is checked in public domain whether the same form of patent is filed or granted or not. Detailed patent application drafting. Filling the patent application. Submission of an application for examination to the patenting authority. Maintenance of the patent once granted. There are two types of patent application. They are provisional patent specification and complete patent specification. In the former, at the time of filing, it needs to explain the invention in detail and have to file a complete patent within a year. If not filed within 1 year, a patent application becomes invalid. In the latter, it needs to explain the invention in detail along with direct application without a provisional one. Patenting organizations are World Intellectual Property Organization (WIPO), Patent Cooperation Treaty (PCT), Intellectual Property India under Government of India, etc. Patents and other rights. Patents seem to have occupied a secondary place while discussing the IPR related issues regarding Internet. In view of the transcontinental nature of the Internet operation, it would be better to minimize infringements by providing better protection mechanisms through better technologies for encryption and decryption. In the context of e-commerce, these technologies play a very important role as they provide the best solution for avoiding unlawful access to what is being transacted on the Internet between two or parties. This secrecy could only be maintained by assigning special keys or codes to the players of e-commerce having unique identification. The concept of digital signature is based on these technologies. The development of digital technology has permitted huge expansion in the capacity for encrypted services. However, at the same time, the sale of unauthorized decoding devices has had an adverse effect on the operators of encrypted services. E-commerce has estimated that unauthorized decoding devices currently represent between 5 and 20% of the total number of devices in circulation. This would promote some Internet service providers and database operators to monopolize such devices and make the users dependent on the operators for many other facilities which the users themselves can arrange. Whereas in India, software is not patentable and these are considered literary works, in advanced countries it is now possible to obtain software patents. These are two advantages of software patents, namely copying of the idea of a patent is prohibited and a stronger legal protection is ensured. One of the reasons of starting software patents is that these are now developed with substantial investment of finances and human resources and are responsible for better functioning machines, novel performance of microprocessors, and when transported through disks, it becomes a tangible product. Layout design or topography. Layout design of integrated circuits is a relatively new area in IP which has appeared with computer technology and has acquired importance as the technology makes rapid advances. The programming instructions on a computer chip are implemented through a circuitry printed on semiconductor materials. The design of circuitry on the chip requires great investment of knowledge, skills and capital, and it needs to be protected as intellectual property. The right in topography aims to prevent copying of the layout design, but reverse engineering to come up with improved design is regarded as fair. Protection of layout design confers no monopoly right. Independent development of a design identical with the protected design is permitted. Undisclosed information. Undisclosed information gets recognition as a kind of intellectual property that needs to be protected under the TRIPS agreement. Earlier to it, the WIPO Treaty 1967 and the Paris Convention recognized unfair competition as a part of intellectual property. The shift in TRIPS to undisclosed information from unfair competition has important implication. Unfair competition includes all acts contrary to honest practices in industrial or commercial matters. Undisclosed information virtually restricts honest practices to protection of trade secrets. The intellectual property thus vests in a creation of human mind involving knowledge, labor and skill. It is the result of sustained intellectual application and efforts of inventors, authors and other creative persons, and is a powerful factor of production and wealth generation in a modern economy. The intellectual property rights, as their exercise has evolved in practice, can secure for the owner a broad range of advantages depending on the national law. For example, intellectual paternity rights can effectively block imports or exports of relevant goods, or they can be used to divide markets or restrict movement of goods produced by an enterprise from one territory to another. To fully comprehend the consequences of national legislation in matters of intellectual property rights, it is important to grasp the rationale behind the law. The chain of production to distribution of goods involves the following major steps: manufacture, first sale by the manufacturer, subsequent sales, exports or imports, use and other dealings. The state has to decide where it should intervene to grant exclusive rights to the owner to ensure just reward for creative activity and best techno-economic returns for the state and the society. Let us now summarize what we have learned in this session. Intellectual property can be characterized as the property in ideas or their expression. The intangible property created by individual or corporation which is protected under trademarks, patent and copyright laws is called intellectual property. Intellectual property right is a collective term which include all these laws. Balancing private and public interests in protecting innovation is the essence of intellectual property legislation. The TRIPS agreement under the WTO recognizes 7 kinds of intellectual property, namely copyright and related rights, trademarks and service marks, geographical indication, industrial designs, patents, layout designs of integrated circuits and undisclosed information. However, the domain of intellectual property is expanding and soon new claimants may arise due to rapid advances in science and technology. In patent filing, an inventor must register his invention in each country where he wants the product to be protected. Here are a few questions for you to work out from what we have learned in this session. Discuss the origin of intellectual property issues. Briefly elaborate the planned patent issues. Discuss on the essence of intellectual property legislation. Elaborate the kinds of geographical indicators of Indian origin. What are the formalities for obtaining utility patents. Here are a few books for your reference. The Ingel Finger Rule Revisited by Angel M. and Cassirer J. 1991, New England Journal of Medicine. General Informatics and Bioinformatics by Anil Kumar S., Kishore Mohan T.C., Murugan K. and Subramanian S. and Books Private Limited, 2011. Working Paper Series by Garima Gupta and Avi Rastogi. Center for Civil Society, K36, Housecast Enclave, New Delhi, 2002. Intellectual Property Rights for Indigenous People, a Source Book by Greaves T., Society for Applied Anthropology, Oklahoma City, USA, 1994. Global Dimension of Intellectual Property Rights in Science and Technology by Wallerstein, M.B., Mogi, M.E. and Schoen, R.A., Washington, D.C. National Academy Press, 1993. Website www.iisd1.iisd.ca/trade/trips.htm. Thank you for watching this session. We will meet in the next session with another topic. Till then, bye.